Hello and welcome to Journey to Justice. Today I want to talk about special educational needs in the law, because for so many families this is something they're forced to learn in crisis, not choice. And for many law students and lawyers, it's an area that looks tidy on paper, but feels messy and emotional in real life. This conversation is about making SEN law clear, honest, and human. Not legal jargon, not gatekeeping, just the law, explained in a way people can actually use. Let's start with what special educational needs really means. Under the law, a child has SEN if they have a learning difficulty or disability and need extra or different support to access education. That definition comes from the Children and Families Act 2014. And here's something parents are rarely told clearly enough. SEN is about need, not labels. It's not about how articulate your child is, how well they mask, or whether someone believes you on a bad day. Schools and local authorities have a legal duty to identify and support children with SEN. Parents are not asking for favors. They are asking for the law to be followed. One of the main tools in SEN law is the Education, Health, and Care Plan, or EHCP. An EHCP is not a courtesy document. It is a legally binding plan. It should clearly set out a child's needs, the support required, the outcomes expected, and who is responsible for delivering that support. The most important section is Section F, which details the educational provision. If support is written there, it must be delivered. Not if resources allow, not when staffing improves. If it isn't happening, the local authority is in breach of its statutory duty. Many parents end up in conflict not because they want to fight, but because plans are vague, delayed, or written in language that sounds helpful but isn't enforceable. That's when trust breaks down, and families are pushed into appeals just to secure what the law already promises. Another important thing to understand is the difference between SN law and disability discrimination law. They are not the same thing, but they overlap. SEN law mainly comes from the Children and Families Act 2014. Disability rights come from the Equality Act 2010. This means a child can be disabled under the Equality Act even without an EHCP. Schools must make reasonable adjustments. Issues around access, exclusions, behavior policies, and exam arrangements can all raise discrimination concerns. For law students and lawyers, this is where public law, education law, and human rights intersect. For parents, it means you are not being difficult when you ask for adjustments. You are exercising rights that already exist in law. So why does the system feel so hard? The honest answer is that the SEN system is under strain. There is underfunding, rising need, inconsistent practice between local authorities, and weak accountability. This is why SEN reform is constantly discussed, and why changes are expected in the coming years. When families are forced to become legal experts just to secure basic support, that is not empowerment. That is systemic failure. Access matters here, and that includes assistive technology, reasonable adjustments, and specialist provision. The purpose of SEN law is not to lower expectations. It is to remove barriers. I want to say this clearly. When the right support is in place, children and parents do not just cope, they thrive. Using assistive technology, flexible approaches, or specialist support is not a weakness. It is evidence that systems are finally working as they should. If you are a parent navigating this journey, your experience matters. Your instincts are often right, and the law exists to protect your child's dignity, access, and right to education. If you are a law student or legal professional, remember that this is not abstract theory. These are real lives shaped by the wording of legislation, guidance, and policy decisions. This is the journey to justice, and no one should have to walk it alone.